damages are easily ascertainable. Which means that if we are going to do asset protection planning for a client like that, it is very important for us to get the planning in place and get it done before a lawsuit is filed. Because if the lawsuit is filed, the plaintiff can quickly go to the judge, get the prejudgment attachment, place the lien on the assets, the prejudgment lien on the assets, and once the lien is in place, there is nothing we can do. It is then too late to do anything. So if we are worried about the possibility of a prejudgment attachment, you have to act quickly. You have to get the work done before the lawsuit is filed. As soon as it's filed, they can go for the prejudgment attachment. Other than the prejudgment attachment, as I said earlier, the plaintiff would need to first prosecute the lawsuit, get a judgment, and once they get that piece of paper from the court, the judgment, now they can look for our client's assets and try to convert that judgment into our client's assets. How do they do that? Well, it depends on the type of asset that they are pursuing. If they are pursuing real estate, then the procedure is very simple. They take their judgment to the local county recorder's office and they record it. It's known as recording an abstract of judgment. It's just a summary of the judgment that they record. Once the abstract of judgment is recorded, it automatically, by operation of law, attaches to any real estate that is in the debtor's name in that county. Okay? Any real estate that is in the debtor's county will be automatically encumbered by that judgment as a lien. Same as a lien you have, for example, to your mortgage lender. They now have a secured interest in the debtor's real estate. And once the plaintiff records that judgment and it attaches as a lien, they can now proceed to foreclose on the real estate because now they're in exactly the same position as any secured lender that you're not paying. You know, you stop making payments to your bank on your mortgage, the bank can foreclose. The same is true with the judgment creditor. As soon as they place the lien on your property, they can foreclose. The property is sold at a foreclosure sale, and then whatever equity they can get out of the property, they will get. For assets other than real estate, there is no lien that you can place on the asset. Liens are for real estate. For other assets, the creditor will actually need to figure out what those assets are and then go to the judge and say, Your Honor, this debtor, he owns a Matisse painting. The Matisse painting is hanging in his living room. Give me a writ of execution. That's what it's called, a writ of execution, to go and seize that Matisse painting. And that's how creditors collect. They need to know what assets our clients own. Bank accounts, you know, what bank is it at, what's the account number, investment accounts, cars, furniture, art, intellectual property, stock in a privately held company. They need to know what those assets are so they can go to the judge, describe the asset with some specificity, and allow the county sheriff to go out there and seize the asset. So, for the creditor, the most important part of this game is access to information. It's all about access to information. If the creditor does not know what assets the debtor owns, how will the creditor be able to go to the judge and say, we want that asset? He can't do that. Okay? So how does the creditor get access to this information? How does someone find out what assets you own? It's not public information for the most part. Real estate is public information, right? But real estate is easy for them to get to. They record the lien, and any real estate that's in your name in that county, the lien will attach to it. What about your bank account? You think the world knows where you bank? It's only in the movies that they can, you know, log into the internet and run some sort of a search, and now they have access to your bank account, and they see numbers moving around. It doesn't work like that in real life. They need to know where you bank, and they need to know what assets you own. How do they find out? Well, there are two ways. Number one, they can go out there and hire, you know, Magnum PI, and Magnum PI is going to go out and look for your assets. What bank accounts do you own? What cars do you own? And what entities do you have interests in? They will dig through your trash, or they will call their buddies at the large local banks, and they will, you know, find out what assets you have. And I've seen some private investigators who are extremely effective. You know, give them about a week, give them about $1,000. They come back with a 30-page report that says, okay, the debtor has a bank account in this bank. This is the account number. This is the exact balance in the account. This is his retirement plan. These are his cars. These are all the LLCs he's ever set up, and so on and so forth. How they get that information, I don't know. I mean, well, I have an idea, but I don't know the details. I do know that for the most part it's illegal, but legal or not doesn't matter to our client, because once the creditor knows what assets the client has, the creditor can go after those assets. Okay, so that's the first way how they get information. Number two way of getting information is through what is known as a debtor exam. And the debtor exam is when the debtor is brought into the court by the creditor, and the creditor gets to ask the debtor any sort of question that they want to about the debtor's assets. You know, tell us about all of your past employment cases, tell us about your prior marriages, give us the names of your accountants and business partners, tell us about all of the assets you've ever owned, tell us about any trusts you may be a beneficiary of or the trust you settled recently, you know, LLCs, corporations, anything that they want that will somehow help them figure out what assets the debtor owns. And the debtor exam is conducted under the penalty of perjury, which means that, you know, all of these asset protection techniques that rely on the debtor simply hiding assets or making assets difficult to find, at the end of the day, they do not work. You know, if the debtor simply, you know, puts cash under his mattress, and the next day he's pulled into a debtor exam, what does the debtor need to do to make sure that this asset protection technique that he just engaged in works? Well, it's simple. He'll have to lie. Because if he tells the creditor that the cash is sitting under the mattress, the creditor will send the county sheriff to collect the cash. So the debtor places himself in a position where the asset protection, for it to work, you know, the debtor has to engage in penalty of, you know, lying under penalty of perjury. And, you know, we all know what happened to Martha Stewart for lying under penalty of perjury. We obviously do not want to see our clients follow in her footsteps, which means that when we are doing asset protection planning, we have to do it in such a way so that when there's a debtor exam tomorrow, our client will be able to answer all of the questions truthfully. He will be able to disclose all of the structures that have been set up, and it still will work. Okay? So asset protection, and I'm a big believer in this, asset protection that relies simply on hiding assets, making them difficult to find, at the end of the day, it rarely works. Because if the plaintiff is determined enough, if they're aggressive enough, if they're intelligent enough, they will pull our client into a debtor exam, and they will force our client to disclose everything that the client knows about his own assets. And obviously the client has all of that information. So I really do not believe in privacy and secrecy, with one small exception. In some cases, privacy and secrecy is advantageous because it may discourage lawsuits. In a lot of cases, the plaintiff's attorney may actually hire a private investigator before they file a lawsuit, just to determine if this potential defendant has any assets worth pursuing. And if the private investigator cannot find our client's assets, it's going to go back to the plaintiff's attorney and say, listen, there are no assets. Now the plaintiff's attorney needs to make a difficult decision. Do I proceed with this lawsuit and take the chance that there are really no assets at the end of this litigation rainbow, or do I simply, you know, look for a different case? So oftentimes, yeah, simply looking for privacy and secrecy may give you a benefit, but it is important that you realize this and that your clients realize that you cannot rely on that. It's nice to have privacy and secrecy, but do not rely on it, because if the creditor is determined enough and if they're intelligent enough, they will get to the assets, they will find the assets. Let us say that the debtor has a bank account in, I don't know, in a Swiss bank in Zurich. And the debtor thinks, like a lot of people do, that if he has a Swiss bank account, that is all that is required to protect that money, because that bank account is difficult to reach. Well, what does it mean that it's difficult to reach? Our client is going to get sued here somewhere, you know, somewhere in the United States. The plaintiff will get a judgment. And once the plaintiff gets the judgment, where is this judgment enforceable? Is it only enforceable in the state where the judgment was obtained? No. the plaintiff can take the judgment to any other sister state